Welcome back to Crypto Republic, where we bring you the latest updates and insights on the world of cryptocurrencies. In today's video, we're going to talk about the SEC versus Ripple lawsuit, specifically focusing on the Bill Hinman documents, which are a set of emails and drafts of a speech given by former SEC Director William Hinman in 2018, where he stated that Ether ETH was not a security. These documents were released on June 13, 2023, and they revealed crucial information that could affect the outcome of the case. So stay tuned and don't forget to like, subscribe, and hit the bell icon to get notified of our new videos. Recap of the SEC's Ripple lawsuit. Before we dive into the Bill Hinman documents, let's do a quick recap of what the Ripple SEC lawsuit is all about. The SEC filed a lawsuit against Ripple and its current CEO, Brett Garlinghouse, and previous CEO Chris Larsen in December 2020, saying that the company's cryptocurrency, XRP, is a security because the company used it to raise funds in 2013. The SEC claims that Ripple and its executives violated the securities laws by selling billions of dollars worth of XRP without registering it as a security or disclosing the risks involved to investors. The SEC also alleges that Ripple manipulated the price and supply of XRP to benefit themselves and their partners. Ripple denies these allegations and argues that XRP is not a security but a digital asset that functions as a medium of exchange and a bridge currency for cross-border payments. Ripple also argues that it did not conduct an ICO or offer any investment contracts to XRP holders. Ripple also claims that it has been operating in good faith and with transparency for years, and that the SEC did not give them fair notice or due process before suing them. Ripple also points out that the SEC's lawsuit has caused significant harm to XRP holders and the crypto industry as a whole. The case is one of the most important and complex cases in crypto history, as it could set a precedent for how cryptocurrencies are regulated in the US and beyond. The case is also one of the rare cases that goes to trial, rather than ending in a settlement. The case is currently in the discovery phase, where both parties are exchanging evidence and information to prepare for trial. The trial date has not been set yet, but it could happen sometime in 2023 or 2024. What are the Hinman documents and why are they important for crypto? The Hinman documents are a collection of internal SEC messages concerning a speech given by former SEC Director William Hinman in 2018. In that speech, Hinman stated that cryptocurrencies like Bitcoin and Ethereum may initially be classified as securities, but as they become more decentralized, can transition into something more similar to a commodity. These documents have been at the center of attention in the ongoing SEC versus Ripple lawsuit, where Ripple is accused of selling unregistered securities in the form of XRP tokens. The Hinman documents were released to the public on 13 June 2023 after Judge Torres denied the SEC's motion to seal them. In this video, we will explore what Hinman said in his speech, what the documents reveal about his views and the SEC's approach to crypto, and why they are important for both the SEC versus Ripple case and the crypto industry as a whole. There were three main sections in the Hinman documents that were revealed today, with the first section being Hinman's speech draft and feedback. This section shows how Hinman prepared his speech and what feedback he received from other SEC staff and external sources. It also shows that some SEC officials expressed concern about Hinman's speech, saying that it could create confusion in the market and expose a regulatory gap that the SEC may not have the jurisdiction to fill. The next section revealed some of Hinman's views on Bitcoin, Ethereum, and XRP. This section shows how Hinman viewed Bitcoin and Ethereum as not securities, but may have considered XRP as a security based on his criteria of decentralization and common enterprise. It also shows that the SEC's Office of General Counsel, or the OGC, advised him not to include a statement directly about Ether in his speech, because it would make it difficult for the agency to take a different position on ETH in the future. The OGT also suggested that Hinman should address how his analysis would apply to other digital assets, such as XRP. The last section of the documents expressed Hinman's disclaimer and policy implications. This section shows that Hinman stated in his speech that he was speaking for himself and not for the SEC or its staff. It also shows that some SEC officials acknowledged that his speech could be seen as representing the agency's views or policy. It also said that his speech could have implications for the SEC's enforcement, actions, and rulemaking. Now that we understand the main sections and points of the documents, let's dive in a little deeper. Hinman's speech was titled Digital Asset Transactions: When How We Met Gary, Plastic, and was delivered at the Yahoo Finance All Markets Summit on June 14, 2018. In his speech, Hinman addressed the question of whether a digital asset offered as a security can, over time, become something other than a security. He used the examples of Bitcoin and Ethereum to illustrate his point. Hinman said that when he looked at Bitcoin today, he did not see a central third party, whose efforts were a key determining factor in the enterprise. He said that the network on which Bitcoin functions was operational and appeared to have been decentralized for some time, perhaps from inception. He said that applying the disclosure regime of the federal securities laws to the offer and resale of Bitcoin would seem to add little value. When I look at Bitcoin today, I do not see a central third party whose efforts are a key determining factor in the enterprise. The network on which Bitcoin functions is operational and appears to have been decentralized for some time, perhaps from inception. Applying the disclosure regime of the federal securities laws to the offer and resale of Bitcoin would seem to add little value, Hinman said. Hinman also said that putting aside the fundraising that accompanied the creation of Ether, based on his understanding of the present state of Ether, the Ethereum network, and its decentralized structure, current offers and sales of Ether were not securities transactions. He said that over time, there may be other sufficiently decentralized networks and systems where regulating the tokens or coins that function on them as securities may not be required. And putting aside the fundraising that accompanied the creation of Ether, based on my understanding of the present state of Ether, the Ethereum network and its decentralized structure, current offers and sales of Ether are not securities transactions. And as with Bitcoin, applying the disclosure regime of the federal securities laws to the offer and resale of Ether would seem to add little value, Hinman said. Hinman then explained how he would analyze whether a digital asset is offered or sold as a security under the Howey test, which is a legal framework that determines whether an investment contract exists. He said that he would focus on the economic substance of the transaction, rather than the form or label of the digital asset. He said that he would look at whether a third party drives the expectation of a return, whether there is a common enterprise between the promoter and the investors, and whether there is reliance on the efforts of others. The digital asset itself is simply code, but the way it is sold, as part of an investment, to non-users by promoters to develop the enterprise can be, and in that context, most often it is a security, because it evidences an investment contract. And regulating these transactions as securities transactions makes sense, the former director said. Hinman also provided some factors that could help determine whether a digital asset network is sufficiently decentralized, such as whether there is a group or individual that plays a significant role in the development and maintenance of the network and its digital asset, whether purchasers reasonably expect that such group or individual will undertake efforts to promote their own interests and enhance the value of the network or digital asset, and whether disclosure laws would apply to such group or individual. But this also points the way to when a digital asset transaction may no longer represent a security offering. If the network on which the token or coin is to function is sufficiently decentralized, where purchasers would no longer reasonably expect a person or group to carry out essential managerial or entrepreneurial efforts, the assets may not represent an investment contract, Hinman said. Hinman concluded his speech by stating that he was speaking for himself and not for the SEC or its staff. He also said that he welcomed feedback and dialogue on these issues. I would like to emphasize that these are my own views and do not necessarily reflect those of my fellow commissioners or staff at the SEC. I welcome your feedback and questions, the former director said. What do the documents reveal about Hinman's views and the SEC's approach to crypto? The Hinman documents reveal some interesting insights into how Hinman formed his views and how the SEC approached crypto regulation. Here are some of the revelations. 1. Hinman and other SEC staff discussed and commented on the draft of his speech, which suggested that Bitcoin and Ethereum were not securities. According to the documents, Hinman received feedback from Valerie Chesapanik, the SEC's senior advisor for digital assets and innovation, who agreed with his views on Bitcoin and Ethereum. Hinman also received input from external sources, such as Andreessen Horowitz, a venture capital firm that invested in crypto projects. Some SEC officials expressed concern about Hinman's speech, saying that it could create confusion in the market and expose a regulatory gap that the SEC may not have the jurisdiction to fill. Some SEC officials also suggested that Hinman should address how his analysis would apply to other digital assets, such as XRP. 2. Hinman did not mention XRP explicitly in his speech, but he may have considered it as a security based on his criteria of decentralization and common enterprise. Hinman wrote that he did not see a need to regulate ETH as a security and planned to call Ethereum co-creator Vitalik Buterin to confirm his understanding. However, the SEC's Office of General Counsel, OGC, advised him not to include a statement directly about Ether in his speech, because it would make it difficult for the agency to take a different position on ETH in the future. The OGC also suggested that Hinman should address how his analysis would apply to other digital assets, such as XRP. 3. Hinman's speech was not an official statement of the SEC, but rather his personal opinion as a director. Hinman stated in his speech that he was speaking for himself and not for the SEC or its staff. However, some SEC officials acknowledged that his speech could be seen as representing the agency's views or policy. They also said that his speech could have implications for the SEC's enforcement actions and rulemaking. Why are the Hinman documents important for crypto? The Hinman documents are important for crypto because they shed light on how one of the most influential regulators in the world views and regulates cryptocurrencies. They also reveal some of the challenges and complexities involved in applying existing securities laws to new and innovative technologies. The documents could have a significant impact on the outcome of the SEC v. Ripple case, which could set a legal precedent for other crypto cases and projects. The documents could also spark more dialogue and collaboration among different stakeholders in the crypto space to develop more clarity and certainty in cryptocurrency regulations. The Hinman documents show that the SEC has not established a clear and consistent framework for determining whether a cryptocurrency is a security or a commodity. This creates uncertainty and confusion for both crypto developers and investors. The documents also raise questions about whether decentralization is a sufficient criterion for exempting a cryptocurrency from securities laws. The documents could prompt more discussion and debate among regulators, lawmakers, industry players, and academics about how to best regulate cryptocurrencies in a fair and balanced way. The Hinman documents also show that the SEC has been inconsistent and biased in its treatment of different cryptocurrencies. The documents suggest that the SEC has favored Bitcoin and Ethereum over other cryptocurrencies, such as XRP, without providing clear and objective reasons. The documents also suggest that the SEC has been influenced by external sources, such as venture capitalists who have vested interests in certain crypto projects. The documents could expose the SEC's lack of transparency and accountability in its crypto regulation. The Hinman documents could also affect other crypto projects and tokens that are facing similar regulatory scrutiny from the SEC. For example, Kick Interactive, which raised $100 million through an initial coin offering, ICO, of its KIN token in 2017, is also being sued by the SEC for selling unregistered securities. Kick has also cited Hinman's speech as part of its defense strategy. The Hinman documents could provide more evidence for Kick and other crypto projects to challenge the SEC's allegations. The documents could also influence the future of cryptocurrency regulations in the U.S. and globally. The documents show that the U.S. is lagging behind other countries in developing a clear and comprehensive regulatory framework for cryptocurrencies. The documents show that the U.S. is relying on outdated and ambiguous securities laws that do not fit well with the nature and characteristics of cryptocurrencies. The documents show that the U.S. needs to adopt a more proactive and innovative approach to crypto regulation that fosters innovation and protects consumers. Possible outcomes of the case. Depending on how Judge Torres interprets these documents, there could be different possible outcomes of the case. Here are some hypothetical scenarios, but they may not reflect the actual outcome of the case. 1. The case could be dismissed on the grounds of lack of fair notice or due process. This means that Judge Torres could find that the SEC failed to provide Ripple and its executives with adequate notice or opportunity to comply with the securities laws before suing them. This could be based on the evidence that the SEC did not treat XRP consistently with other cryptocurrencies like ETH, that the SEC did not issue any formal guidance or warning on XRP, and that the SEC waited too long to file the lawsuit. If this happens, Ripple and its executives would be cleared of any wrongdoing, and they could resume their business operations without any regulatory interference. 2. The SEC could be ordered to pay damages or penalties to Ripple and its executives for bringing a frivolous lawsuit. This means that Judge Torres could find that the SEC acted in bad faith or with malicious intent when suing Ripple and its executives. This could be based on the evidence that the SEC had a bias against Ripple and XRP, that the SEC leaked confidential information to the media, and that the SEC harmed Ripple's reputation and business prospects. If this happens, Ripple and its executives could receive compensation for their losses and expenses caused by the lawsuit, and the SEC could face sanctions or disciplinary actions for its misconduct. 3. The SEC could be forced to clarify its stance on the status of cryptocurrencies and provide clear guidance for the industry. This means that Judge Torres could find that the SEC's approach to regulating cryptocurrencies was vague, inconsistent, or arbitrary. This could be based on the evidence that the SEC did not have a clear definition or test for determining whether a cryptocurrency is a security, that the SEC applied different standards to different cryptocurrencies, and that the SEC did not communicate its expectations or requirements to the industry. If this happens, Ripple and its executives could still face some liability or settlement for their past actions, but they could also benefit from having more certainty and predictability for their future operations. The SEC would also have to establish a clear framework or rulebook for regulating cryptocurrencies and ensure that it is applied fairly and uniformly to all market participants. 4. The SEC could appeal the decision and prolong the litigation. This means that Judge Torres could rule in favor of Ripple and its executives, but the SEC could disagree with her reasoning or findings and challenge them in a higher court. This could be based on the SEC's belief that it has a strong legal basis for its case, that it has sufficient evidence to prove its allegations, and that it has a public interest duty to protect investors from fraud or manipulation. If this happens, Ripple and its executives would have to continue defending themselves in court, and they would face more uncertainty and costs. The litigation could drag on for months or years before a final resolution is reached. Conclusion: where are we now? As of June 2023, the current status of the case is that both sides have the deadline of November 30, 2023 to file their summary judgment motions, which could end the lawsuit without a trial. The judge could grant either side a win without a trial or decide to narrow the issues that go before a jury. The case is also awaiting the judge's decision on whether to shield the opinion of an SEC expert who has faced threats and harassment over his involvement. The case is expected to have a significant impact on the future of cryptocurrency regulations and determine if XRP is a security or a commodity. Meanwhile, the U.S. Congress House of Representatives Committee on Agriculture has held a hearing on June 6, 2023, called The Future of Digital Assets, Providing Clarity for Digital Asset Spot Markets, where Paul Grewal, the Chief Legal Officer, CLO, at crypto trading platform Coinbase, and other speakers testified on the need for clear and consistent regulation for cryptocurrencies. This hearing could also have an impact on the case and the future of crypto assets. While the case is still in the discovery phase, where both parties are exchanging evidence and information to prepare for trial, the trial date has not been set yet, but it could happen sometime in 2023 or 2024. The case is one of the most important and complex cases in crypto history, as it could set a precedent for how cryptocurrencies are regulated in the US and beyond. While no one knows for sure what the outcome of the case will be based on what we know so far, the outcome of the case could depend on several factors, such as 1. How Judge Torres interprets and applies the securities laws and the how we test, 2. XRP and Ripple's activities. 2. How the judge evaluates and weighs the credibility and relevance of the witnesses and documents provided by both parties, especially the Bill Hinman documents. 3. How Judge Torres considers and balances the interests and rights of the SEC, Ripple XRP holders, and the crypto industry as a whole. 4. How Judge Torres responds and reacts to any motions, objections, or appeals made by either party during the trial. Based on these factors, some possible outcomes of the case are: 1. The case could be dismissed or settled in favor of Ripple if Judge Torres finds that XRP is not a security, that Ripple did not violate the securities laws, or that the SEC did not give fair notice or due process to Ripple before suing them. 2. The case could be decided or settled in favor of the SEC if the judge finds that XRP is a security, that Ripple violated the securities laws, or that the SEC had a valid and reasonable basis for suing them. 3. The case could be partially decided or settled in favor of both parties if Judge Torres finds that XRP was a security at some point, but not at others, that Ripple violated some but not all of the securities laws, or that the SEC had some but not all of the authority and evidence pursuing them. That's all for today's video. I hope you found it informative and interesting. If you did, please give it a thumbs up and share it with your friends. And if you want to see more videos like this, please subscribe to our channel and hit the bell icon to get notified of our new videos. Thank you for watching Crypto Republic, and I'll see you next time.